Hello, friends. I'm Amol, and I hope that all of you are doing well and keeping safe. In the next few episodes of the Lex Prudence podcast, I wish to share some of my professional experiences with you all. The intent here is to share some incidences, matters, or issues that have taught me a thing or two and have helped me grow as a professional. Litigation management is one of the most important areas of practice for in house counsels. But litigation management does not only mean handling or contesting litigation, filing of plaints, petitions, replies, affidavits, and rejoinders. But a lot of times, litigation management for an in house counsel means achieving certain strategic business goals through litigation. Those goals may not always be in the form of winning or losing litigation matter. This is where the term strategic litigation and litigation strategy come into picture. The field of strategic litigation or litigation strategy has steadily grown over a period of years and has now become one of the most critical areas of an in-house counsel's role. Today, I'll share one small example of how litigation strategy works for an in-house counsel in achieving his or her business goals. For obvious reasons, I'll not share names of the organizations or the parties and will only focus on the facts and learnings as that's what we are focused on. So let's begin with the small case study. XYZ Limited had entered into a leave-in license agreement for one of its office premises, which was meant to serve its high net worth customers. The office was obviously located in one of the most poshest areas of the city and was an expensive property commanding high rent, let's assume 20 lakh rupees a month, and also had a very high security deposit. Let's assume an amount slightly higher than 1 year worth of rent, which is approximately 2.5 crores. The agreement was a long-term agreement and had a lock-in for XYZ Limited for a period of 3 years, with a possibility of termination only after the lock-in period or within the lock-in period only in case of a material breach of a contract by the licensor. Sometime after the first year of the license period, XYZ Limited realized that the markets were slowing down and they did not need a separate high-end property only for HNI customers, as HNI business was anyways shrinking. Also, the costs of this property were so high that it no more made a commercial sense to keep this property, which had become a white elephant for the company. All the business negotiations with the licensor of the property had failed. The licensor obviously had the lock-in period to his rescue. The matter was then referred to the legal team to have a look at the agreement again and see if there is any legal remedy possible. Now, 3 business objectives that they had to achieve were as follows. A. Get rid of the fixed costs worth rupees 20 lakh rupees a month for the company. B. Secure the return of security deposit of rupees 2.5 crore. C. Avoid the cost worth around 5 crore, that is rent for 2 more years, that is up to the end of the lock-in period. Now, the legal recourse that was available for the legal team under the contract was as follows. A. Find a breach on the part of the licensor. B. Ensure that the breach is a material breach as part of the contract. And C. Terminate the contract on the ground of material breach of the contract and secure refund of the security deposit post termination. While the legal team was able to find a few misrepresentations, or rather I would call them as breach of representations by the licensor in the form of some non-payment of past municipal dues for the property, which were represented by him as paid at the time of execution of the contract, the legal team was not very sure if the same would qualify as a material breach on account of the fact that the agreement was slightly ambiguous or silent about it. Now, you'll appreciate that the civil dispute usually takes a humongous amount of time, money, and resources to get resolved. And thus, waiting for a end result of a dispute was not an option, as that would not help in achieving the above commercial objectives that we spoke about. Having considered all options available at their disposal, the legal team took the following interesting route. 1. Serve the termination notice for breach and demand refund of security deposit on account of breach of representations towards payment of municipal dues. Obviously, the landlord will deny that it is a material breach. He wants to secure the rent for the lock-in period. Move ahead with the dispute resolution since the licensor would not admit any breach and hence not allow the agreement to be terminated. 3. While the matter is pending adjudication, file an interim application with the court and secure following interim reliefs. A. That the licensee shall deposit rent with the court pending adjudication, and B. The licensor shall also be ordered to deposit the security deposit amount with the court till the matter is pending. Now, the above strategy resulted in two important things, or rather three important things. 1. The licensor stopped receiving the regular rental income as it was deposited in the court. 2. The licensor also lost control over 5 crore worth of interest-free security deposit money lying with him. Not 5 crore, 2.5 crore worth of interest-free security deposit lying with him. And 3. Property is also blocked for the duration of the pendency of the litigation. That kind of leaves him dry. Otherwise, he would have used the same money, which is licensee's money, for managing the dispute. Now, all the three above factors made the licensor to think of an amicable resolution of the matter, and the company could finally settle the matter by payment of 6 months rent amounting to 1.2 crore, but at the same time securing the majority of business objectives that they wanted to achieve. A deed of settlement was executed, terms of settlements were filed before the court, and the suit was withdrawn as settled. Now, friends, I could gather the following learnings in terms of a strategic litigation from the said experience. And what are those learnings? 1. Always know your rights, obligations, and remedies under a commercial contract. 2. A litigation matter can never be considered solely from the point of view of its end result, but you have to keep an eye open for other interim short-term results also. 3. Know and understand the procedural law to make sure you move the right applications at the right time. 4. An in-house counsel needs to keep his/her options open at all times and weigh which option to use, when, and how. Timing is of the utmost importance. And 5. Always have the commercial bent of mind and look for closures that are commercially win-win for both the parties, and you will have a satisfying litigation experience for the organization. So friends, do you have any such interesting experiences to share? Do share them with me. Let's learn and grow together. I hope that today's discussion would urge you to do some research, would urge you to dig into your experiences and share them with me. And I'm sure we'll have a mutually enriching experience. Just search for Lex Prudence, LEX Lex -PRUDENCE Prudence on your favorite podcast platform, Anchor, Spotify, Google, Breaker, or Radio Public, and listen, subscribe, and share. And don't forget to send in your comments and feedback. Have a great day and take good care of yourself. Goodbye.